some 5x5s. Just got some breaking news, and then I'll get into my main planned show for today. I'm headed off to go work out. So, as you know, I'm trying to kill two birds with one stone. Sorry, I started a little bit late. Just had a phone call I had to deal with a client. Took a little bit longer than I wanted to, but I'm here now. Hopefully you guys can hear me. Throw me a 5x5 if you can hear me, so I know what's going on. And then we'll start the big shoe, the really big shoe. All right, cool. Thanks, Greg. Thanks, Simba. Hey, Kevin. Good seeing you, bro. So today I'm going to cover a couple topics. One of them is going to be the Salina versus Texas case. This is the case that Chile cites for the proposition that you don't have the right to remain silent. And I'm going to explain it to you in a little bit more detail because there are some, I think it was wrongly decided. I think it's unconstitutional, but unfortunately we have a bunch of politically appointed black robers who think differently. And I agree with the liberal majority on this case. I think that it was just a big mistake. But hey, what's going on, Bibi? Bibi Houstons. All right, so let me get on the road. So as a lot of you guys know, I blew out my back, so I've been trying to hit the gym and do my stretching and all that good stuff. So I figured, this is a great way for me to cover in California and Texas. I primarily do personal injury law, catastrophic injury cases involving serious motorcycle accidents and big rig trucks, municipal buses and stuff like that. But I have a background in appellate law, criminal defense, and civil rights, and I still do catastrophic injury cases involving tight handcuff cases with amputations and police shootings. So those are the primary cases that I am involved in, catastrophic serious injury claims. And my first love is the Constitution and the Bill of Rights and natural law. And so today I'm going to break a story you may have already heard from Reluctant Prophet that Lane Myers ended up pleading out, and that would explain why I didn't have my live with him the other day. Probably was in court or unavailable, contemplating what he had to do here. And so from my perspective, I feel terrible that he had to plead out, but I also know that 95% or more of criminal cases, especially when you're in custody, where you're deprived of your freedom, result in a guilty plea. And that's what happened here. And so typically when you enter into a plea agreement, which is what it appears Lane did, sorry, I'm driving, so the thing's bouncing around. Typically when you enter into a plea bargain, which is what it sounds like Lane did, is you'll get a reduced sentence, or you'll plead out to a lesser included offense in exchange for a guilty plea, so you can forego trial and the risks of a runaway verdict against you, for example, as a criminal defendant. Yeah, I feel terrible too, Gloria. And I don't know if all of you have heard yet, but I just found out this morning from Reluctant Prophet, and he's got a lot more on his channel, so make sure to go and like and subscribe to Reluctant Prophet's channel. And also make sure to like and subscribe and double tap your screen for me too, so we can keep my channel going. We know that the thought police over at this particular platform, I don't even want to say the name because their AI is so smart now, they target people like me who are freedom fighters. They don't like people who believe in individual rights or fight against the CDC or the FDA, go against the official science and all that stuff. So I've had nothing but problems. People who support the ideas of Julian Assange, for example, they're considered to be fringe, I guess. And so I'm always on the edge, teetering on losing the show completely. So please always make sure to like and subscribe and save the videos for later, and also record them. Please do that. And also, if somebody can help me set up a second channel, just in case, because you just never know. I heard that it's always good to have a second channel. So if anybody has any ideas how to do that, please reach out to me. All right, so let's get into the meat of it. So in one of my previous episodes, we talked about Lane Myers and the statistical probabilities of him going to trial. And I said straight up that 95% or more of criminal cases where you're a defendant end up in a plea bargain, in a plea agreement, plea bargain. And it appears that that is what took place here. And obviously, when I get more information about it, I'll share it with you. But right now, from what I understand, it looks like he pled out to 2 felonies. Okay, the problem with these, another problem among many things with these plea deals, is you don't know what the judge is going to do. Okay, so you make a deal with the prosecutor, and in this case, we know the prosecutors, city and county, hate his guts, so they're stoked that they're getting this conviction, because I believe that he could have won on appeal if he did lose a trial. And I also felt like it was kind of sort of a self-defeating thing to plead out when you don't know what the sentencing is going to be. Like, he could still end up in jail for a long time, right? And so it almost makes more sense to roll the dice and go to trial. At least that's my perspective. But again, I'm not the criminal defendant, so it's really hard. It's real easy to be an armchair lawyer. It's real easy to try and put yourself in the shoes of the defendant. But if you're in jail, if you've ever been in jail, you probably understand that it's no place you want to be, especially when the government is against you and you have corrections officers who are against you. And in Lane's case, he was complaining that one of the correctional officers attacked him physically. So from my perspective, it's the worst place in the world to be. The problem is, when you enter into a plea deal, especially on felony charges, that doesn't mean you're getting out of jail. All right? So don't assume that Lane's getting out of jail, guys. That's the problem that I have with this whole thing, is that my approach would have been to immediately go up on a writ when the trial judge denied Lane's motion to disregard or dismiss the case, or at least the charge of harassment, because it's a vague and ambiguous and, as applied, unconstitutional statute. At least that's what I would have argued if I was in California or Texas. And again, I'm only licensed to practice law in California and Texas, so I can't give you legal advice about what would happen in Arizona, because I'm not licensed to practice law there. But I could say federally, from a purely constitutional point of view, that statute is null and void, ab initio, like from the beginning. I don't think that it's a valid statute. I think that he had a very good chance at getting it reversed at the appellate level. At least that part of his case knocked out, all right? Which I believe was the significant part of his case. So in this case, I think he was charged with, like, what was it, 20 felonies or something? So he's looking at like 20 or 30 years in prison. So he pleads out. But the problem is, again, just because you plead out and you say your plea was knowingly and voluntarily entered into, which should technically forego any appeal, or even if that statute is overturned later, for him to go back and argue that as applied to him it was unconstitutional. It basically locks him in. It's a real problem. So the big problem here for him is that just because he pled out doesn't mean shit. There's still a probability that the judge is going to give him additional time in jail, maybe 2, 3, 4 years, who knows. So I'm not really sure what the strategy was here, but I feel for the guy, and I think that he got a raw deal, and I think it's mainly because of his personality, because I think, based on my understanding, Lane has a brain injury, I think. Don't accuse me of defamation here, but I believe, based on my understanding, that he has a brain injury and he suffers from PTSD. And I know guys like that who are Marines who act just like him, and I guess that's why I understand him, and I don't have the same negative sentiment towards him that maybe the courts or other lawyers might, because I'm a blue-collar guy who became a lawyer later in life. But my background is being a Marine, being in construction, being in the health club business, being a personal trainer, and all that stuff. So I'm used to being around regular people. Had a limo business. Had Rodney Dangerfield was one of my clients. I was his chauffeur. So I've had a more well-rounded perspective on life. So when I see guys like Lane, I understand what he's going through, and people act just like Chili. People are just different, but it doesn't mean just because they're loud or they do things differently than I would as a lawyer doesn't make them any less of a human. And so I've got a lot of respect for both those guys. I consider them both to be freedom fighters. So, hey, let's OTVO. Good seeing you, brother. And Simba B, probably Integrity Now News said it best. They broke him, and that's what you do. And so it's easy for you guys, especially like the frauditor guys. I'm sure they're all going to be coming out of the cracks saying, see what I mean? See, I told you so. Hey, look, man, just like a lot of those Jan 6er guys, they were locked up in 10 by 10 cells. They were allowed access to counsel. They were disallowed access to counsel, and as a result, they pled out to bullshit charges, and that's one of the reasons why they were pardoned. So not all of them, but the ones that, and then, you know, the ones that were jailed on obviously specious charges because it was purely political, right? It was just a political persecution, just like it was with Chili, just like it was with Lane. Same thing, political prosecution. So just in closing on the Lane Myers case, I will cover more later, and I'll do a lawyer breakdown video on what I learned from Reluctant Prophet. And I'm hoping that I can do a roundtable with Reluctant Prophet. This is a public service. And maybe even Lane when he gets out. But we don't know when he's going to get out. So that's going to be the problem, guys. Lane Myers still languishes in jail. And if he gets sentenced on these felony charges, my guess is that he'll be sent to state. In other words, I think he's in a men's jail or an adult jail right now. But because he's pled out to these felony charges, allegedly, I don't know everything yet about the case. I'm going based primarily on hearsay and the evidence that I have from people that I know who are more in the know than I am, that's what happened. So again, always, and I tell you guys all the time, do your own research. Never take anything I say for gospel. But do your own research. I think that you'll find that this is true information. And assuming arguendo that it is true, now it's the sentencing phase, similar to a trial. You get convicted, and now you go through what's called sentencing. And so I don't know, I think, based on what I heard Judge Metcalf say, that he has a couple of weeks to sentence Lane. And I believe that they denied Lane his bond hearing, or they denied him a bond. They're trying to make him out like he's like this dangerous criminal, right? So as a result, Lane is going to be languishing in jail for quite some time, until such time as, well, let me get around this idiot. Until such time as he gets his sentencing hearing, and then we'll find out. Now, yes, he probably will get time served, but because the victim really hates his guts, and I believe because the victim's a government employee, the alleged victim is a government employee married to a prosecutor, that there's a high statistical probability that he's going to get the book thrown at him on the charges that he did plead out to. And so as a result, it's my opinion, just my opinion, that he's going to probably get sent to a state prison to serve on these felony charges after he gets sentenced. So what I'd like you guys to do is not look at Lane like he gave up, not look at Lane like he's a bad person or that he's no longer a freedom fighter. Just look at it like he got railroaded, which is what I believe a lot of you guys already believe. So with that being said, that's sort of the end of the Lane Myers saga for today. So the next case that we're going to talk about is going to be Salinas versus Texas. All right, so the Salina versus Texas case is a U.S. Supreme Court case involving a criminal defendant who was apparently a fugitive from justice for like 15 years, and ultimately he was arrested. And rather than say, I invoke my right to remain silent, he went ahead and didn't say anything. And so me being a constitutionalist and me agreeing with the minority opinion led by Justice Breyer, me agreeing with Justice Breyer and the minority, the liberals on the court, I believe that he didn't have to invoke his Fifth Amendment right. I mean, it's pretty clear. You have the right to remain silent, period. You understand, guys? You have the right to remain silent. And so Chile de Castro schooled me on this one. I just didn't want to believe him, and I've just been in denial about it because it's such a wrongly decided case, in my opinion. But let me give you some caveats and sort of distinguish Salinas in what you need to understand about it. So Salinas has to do with a non-custodial detainment, right? And that's just an artful way for the police to say that you're not under arrest. Now, it's my position that as soon as the police stop me, I'm under arrest. And I would argue, if I had been Salinas or his attorney, I would have argued I was under arrest. I was not in custody. I was under arrest. I was not free to leave, and I had the right to remain silent. But obviously, this to me, this was more of a political case than anything, because it involved, I believe, he was a murderer, and may have made the court look bad if they let him get off on what many people call a technicality. In other words, if I abide by the Constitution, as a judge, people will accuse me of letting him off on a technicality. You guys understanding me so far? So, yeah, little arrest and big arrest. That's right, Greg B. But there's an older Supreme Court case, I believe it's called Quinn, that I would have relied on and that I think is really the binding authority here. But it doesn't matter, because it's the Supreme Court that gets to decide this, not me. Even though I believe that it was wrongly decided, I'm not going to sit here and trash these judges and tell them that they're fascists or whatever, because it's not going to do me any good. So, ultimately, that was pretty cool. A bagger just blew past me on a Harley bagger. It looked pretty dope. All right, so let me just kind of try to help guide you on some things that you should be aware of to help distinguish how this works. So in a non-custodial situation, according to Salinas, you do not have the right to remain silent, or the Fifth Amendment right isn't going to apply to you if you remain silent. And because of that, inferences can be drawn by your silence. And so there's an ancient maxim in law, goes all the way back to English common law, that failure to deny is an admission. So when they questioned him about what he had done, about allegedly unaliving someone, sorry YouTube, I got to say unalive, I get it. I'm probably going to get yellow flag now because I think I said the M word at one point. But because they were interrogating him allegedly while he was not in custody, but they're interrogating him, so I don't see how he couldn't be in custody, that because of that, it appears as though reasonable inferences were drawn based on his silence that he could potentially have been guilty of the allegations that he was being questioned about. And so I just think that it was a wrongly decided case. So you're only, if you're being questioned at a traffic stop, you're considered to be, according to Salinas anyways, based on the inferences I drew from the case, you're considered to be in a non-custodial situation. Now, my personal feeling is, as a lawyer and as a free man upon the land, is that as soon as my freedom is stopped, I am now under arrest. So that would be my argument, that no, this was never a non-custodial situation. I was in custody. But it looks like the Supremes are saying, no, until you've been read your Miranda rights, you don't have a right to remain silent, which I think is absurd. So basically, it's a bunch of gibberish as far as I'm concerned, but the argument that they're making, that the Supremes are making, the majority is making, is that as long as you're not in legal custody and you haven't been read your Miranda rights, you have to expressly invoke your Fifth Amendment right to remain silent. You have to verbalize it. Of course, if you're deaf, I don't know how you're going to do that. You might be able to put it on a piece of paper. Now, let me tell you another reason why I have a real problem with this case. Because the police have the right to use furtive and non-furtive situations to infer guilt or innocence of a party or someone who's being stopped, a detainee. So your voice inflection and deflection, the way your lips move, or they could even allege they smelled an alcoholic beverage or the smell of MJ as soon as you open your mouth, and use that as an independent basis to make an arrest, what they call an arrest, because I believe you're already under arrest, but that's a conversation we'll have another time. But the bottom line is, I don't like the Salinas case. I think it was wrongly decided, just like I think that Lane Meyer's pleading out was based purely on, was purely based on, hold on a second, guys. I believe that Lane Meyer's pleading out was purely based on him being basically strong-armed into doing it, that it was done under duress. That's my opinion. So, and Lynn Davidson, I agree with a lot of the things that you're saying, but I'm going to go with what they're saying is the law, because that's what you're going to deal with and what you're going to have to, you're forced to deal with at trial. So, and Simba B says, can you have a no comment interview? Yeah, of course. So Diesel says the people, play says louder lie, mislead, trick, speak form of legalese. That's not clearly understood. Lynn says there has to be a verified complaint. Yeah, I understand all that. I get all that. But unfortunately, none of those arguments work. So I'm just going to go with what you guys are going to be faced with. So really quickly, I'll just recap before I hit the gym here. The Supreme Court held that a suspect must expressly invoke the Fifth Amendment right to remain silent for it to be protected during a non-custodial interview. All right? Simply remaining silent or failing to answer questions does not automatically invoke the privilege against self-incrimination. Salinas stayed silent when he was asked about evidence during a voluntary police interview. Okay, so this is a little bit different than a traffic stop, but guess what, guys? As soon as you talk to a cop at a traffic stop, it's considered to be a consensual encounter. So it's no different than a police interview. So I want you to understand that. If you engage in a consensual encounter with the police, anything you say can and will be used against you, period. So you have to expressly invoke your Fifth Amendment right. You just can't not say anything and expect the Fifth Amendment right to apply to you. Now later, you can argue at trial or during a motion to suppress that you were under arrest, that I believed I was under arrest. But again, you've got to convince a judge to go along with that. Most judges are former prosecutors, so good luck with that argument, okay? I'm just trying to help you guys understand what's going on. Yeah, well, that's right, Lynn. So silence can be deemed an admission, and that's an ancient maxim of law. So he stayed silent when he was asked about evidence during a voluntary police interview. I don't know why he would volunteer to that. I would immediately want to have a lawyer present. But the prosecution used his silence as evidence of guilt, and the Supremes ruled that this was permissible because he didn't expressly claim his privilege. So, and there are other cases like Kansas versus Cheever, as well as, let me see here, United States versus Sarnev. Remember that guy, the Boston Marathon guy? He blew up a bunch of stuff. That have cited that case, and it's been upheld. So it's a problem. And now I agree with the dissent led by Justice Breyer here, and I think that he cited, I think the Quinn case. Let me see here if I have it. I may not have written that one down, but in any event, that's the case. And so again, Chili de Castro is right again. And I'm not going to say that I was wrong, but I was definitely not happy about it. I'm not happy about this case because I believe it's wrongly decided. It goes against my understanding of what the Constitution and the Bill of Rights means. So Salinas versus Texas is now a cornerstone requiring verbal invocation of the right to remain silent unless you're in a, well, whether or not you have a right to remain silent in a traffic stop, because I would argue that as soon as you open your mouth, you're consenting to being interrogated, but I would say that a traffic stop would apply to be the same way, that you'd have to verbalize it. I would typically say, I want to help you. I'll answer any questions that you have for me, but first I need to have my attorney present. That's one way to handle it. That's just me personally. Cop Talk says never talk to cops. Well, I agree that's as soon as you open the door, you're opening the ability for them to say, hey, he was stuttering or he was slurring his words, and therefore he seemed like he was drunk. So you're damned if you do, damned if you don't. One of my good friends many years ago, about 30 years ago, who was one of the first real sovereign citizens before they had the camera phones and all that, he said, just don't get pulled over. Just don't get pulled over. And I got to tell you guys, that's the best advice I can give you. Just don't get pulled over. Let's OTVO says it's getting easier and easier to violate rights as more and more people accept the ignorance of tyranny. Absolutely. I agree with that. Absolutely, man. You are right, my brother, my Navy brother. Let's OTVO. So staying silent without stating I am invoking my right to remain silent may allow prosecutors to use your silence in court, potentially as an admission. So be very careful with that. And then during a traffic stop, yeah, I think Chile is on point that you should say I'm invoking my Fifth Amendment right to remain silent to ensure the legal protections of Salinas. Now, another thing that you could do, I've seen this done before, I'm not saying to do this, but I've seen people take a piece of paper that they already have planned and they put it up against their window that says, I'm invoking my right to remain silent. Now, at least that would prevent you from having to open your mouth and allow the cop to use some kind of an observation that you slurred your words or something like that as an independent basis to make an arrest. In Pittman Adams, I would say that in principle, I think that you're right, but the right to travel is not the same thing as the privilege to drive. And remember that the government has an easement on the roads. And because they have an easement on the roads, they have the right to enforce their licensure requirements and registration requirements. Remember, the original vehicle code was only designated to be for commercial vehicles. But over time, it evolved to include private conveyances. And the registration and all that other stuff, licensing requirements, are now being, I think, silently enforced based upon these easements. So yeah, you definitely have the right to travel, but if you want to travel on the King's roads, you have to pay the toll. That's the only thing I can tell you. Do I agree with it? I think it's wrong, but that's how it's going down right now. So guys, I'm going to go hit the gym. It just was a short little video. I wanted to share that with you guys who are not sure. I had an expert witness come on who is a retired whistleblower cop yesterday, and I talked to him a little bit about that in yesterday's live, and he agreed with me that anytime you open your mouth, the cops are going to use that to try to find a way to get an arrest or figure out something that's wrong with you to justify additional detainment and a potential custodial arrest. So with that being said, hey, Dad, love you, brother. Good seeing you, man. And for those of you who just joined me, it does appear that Lane Myers has pled out to at least 2 felonies. He's still languishing in jail. He still is going to have a sentencing hearing. He was denied bond, and this is all based on good authority. I'm not 100% until I see it with my own eyes, but on good authority from people that I trust with my life, that's what's taken place. And obviously, I don't feel happy about it, and it's not something I would have recommended doing. But again, don't be an armchair lawyer. Try to put yourself in Lane's position. He is being deprived of his freedom, and when you're deprived of your freedom, you can get broken quite easily when you're being tortured in a dungeon like that. So With that being said, guys, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. All right, I'll try to, I think I may go live later. Not 100% sure. But with that being said, Semper Fi, do or die.